Welcome to Inheritance Solutions for a Diverse Community with Richard Hall. Join us as we delve into strategies and insights that ensure your legacy is secure and your loved ones are cared for.
Hello and welcome to Inheritance Solutions for a Diverse Community with Richard Hall, founder of Bottom Line Lawyers. Richard combines extensive legal and real estate expertise to help clients with estate planning, as well as to protect their families' futures. I am your host, Kevin Rosenquist, and today we're going to be talking about kids protection planning. We're going to talk about what every parent needs to know and why they need to have a plan in place. Richard, so good to see you again. Welcome back.
Thank you very much, Kevin. Good to see you as well.
So can you kind of explain what kids protection planning is and why it's so important for parents to do?
Again, this is one of these topics that people don't really want to think about. Well, what happens if you're in an airplane that goes down, mom and dad,
Right.
and their kids are left behind? You need something in place to make sure that they're taken care of the way you want them to be taken care of. Make sure that they're raised the way you want them to be raised, that their values are commensurate with what your values are. And the only way you can do that for certain is to put it in writing, like most other things, if you really want it to happen. There's not just who takes care of them, where are the funds coming from to take care of them after you've passed? And so that gets into issues of insurance and other types of estate planning, like a trust and so forth, even for a young family. And that's probably where it's most critical, because if you've got children that are, under teenage years, right? They're preteen or infants. They need a lot of support. They need support in school. They need financial support. They need somebody to be able to, take them out and get clothes, get them their health care, make sure that they eat well, all those things. And that responsibility is going to fall to someone. Who is the someone that you want to have do that for your children? And that's what you are going to prescribe inside of your will. So, without a written instruction about who's to take care of your children, it's going to go to a court, and a court's going to decide based on the kinship relationship. And it may be your brother who's perhaps a ne'er-do-well, or someone else that you just don't want to have raising your children. And you don't want that to be left to a court. You want it to be that judgment, that decision needs to be in your hands.
What are the factors that the court looks at in the situation where parents don't have a protection plan in place to help decide where the child should go?
By far and away, the single biggest aspect of that they're going to look at is the familial relationship between the deceased parents and who should take care. Now, they will look at what that person does for a living, if they're settled in their life or not, if they have other children that might help with in the context of a blended family, might look and see if that other with the closest family relationship is someone who's also married. It would help in terms of raising children. It's really looking at what is the first and foremost is going to be the family relationship. Secondarily is their ability to provide for those children. And third, probably more important to the parents, but not necessarily to the court, is the familiarity in values and nurturing relationship between this nominated person, or the person the court wants to appoint, and the children.
Does the child opinion matter?
If they're under 12, no. If they're 12 to 18, the court will consider, but it's not dispositive. If they show up in court and the child says, "No way, I don't want to go with him or her," the court is certainly going to weigh that. And then what if there's no alternative? What if there's, the deceased parents have one sibling between them?
Right.
Sometimes children are awarded to the grandparents because they're the most suitable. And sometimes grandparents will, step up and raise their hand and say, I'm happy to do that. I'd love to raise my grandchildren. So it's going to vary, but again, I'm going to, stereotype a little bit, but it's certainly when adults are younger, they don't necessarily always agree with your parents, right?
Right.
And they may not agree with the values that they were raised under, and they don't want their children raised under that particular set of values. Either they're too strict, or they're too lenient, or they're too this or too that, whatever. The court's going to consider a variety of things, but always the best choice is the parent's choice.
I can tell you my parents could not handle my son. So that would not be a good decision by the courts. That's for sure. So is this kids protection plan, is it a standalone document or is it part of the will?
It's part and parcel of a good plan, whether that's the will. In fact, the portion that deals with children is in a will, whether that's pour over will or standard will. So pour over will you use in conjunction with the trust. Standard will is a standalone, right? Either way, that is going to be specified in the trust. And that means having names and contact information and all that. And in the case of someone to take care of your children, I would want those people that you designate to acknowledge that and accept it.
Mm-hmm.
Don't always, right? No, I don't want to raise your kid, right?
Yeah.
That's a reasonable response. It's not a burden that they volunteered for.
It's a big ask.
It's a big ask.
Yeah. As far as legal documents are concerned, is there anything that's different as far as if you're incapacitated versus if you pass away? Like, do you separate that somehow?
You mean in the context of
the kids? Yeah, like maybe you have someone that you're cool with. They live really close. They're your neighbor. Or if you're incapacitated, they're cool with your kids. You're cool with your kids going to them, but you wouldn't necessarily want them to raise your kids if you pass away.
Well, it's interesting. A lot of permutations on that question. So if one parent becomes legally incompetent or unable to raise the kids, they're still the other parent. Whether they're divorced or not is not really relevant. It's still the birth parent, right? But under the circumstance where both parents are injured in a accident or something like that, then you still want to go to whoever they've provided inside their will. And the reason for that is the court doesn't have any other place to look. So there's not like, okay, if it's a 6-month stint, they can do it. But if it's a lifetime stint, they can do it. You don't have that particular provision. And remember, if somebody has your power of attorney for finance purposes and your power of attorney for healthcare purposes, they stand in your shoes and they're going to make the decisions that you would otherwise be making. And that includes parenting decisions. So they have the right to do the things that you would have done if you were able to. And so there isn't a need for a specific document that says, yes, they can do this because the power of attorney covers that. If you wanted to circumscribe what an agent could do under the power of attorney with respect to your children, you could do that. You certainly can make that a provision. But generally speaking, it's just added in as part of the will or pour over will.
Okay. How does it change when you have a college student? Because it's a little different of a nuance there.
Well, college student generally is going to be over 18. So technically they are an adult and they can make their own decisions, right? Where I think it becomes more relevant is the financial support.
Right.
And so in a power of attorney for finance, again, we're giving general powers there. And those general powers are usually specified what the range of powers are, but it would include pulling money out of investments or savings or liquidating an asset that's no longer needed in order to pay for college costs. But that is going to be at the discretion of the agent for power of attorney. It's not one that's specifically set forth in the document unless you choose to do that and say, okay, I want this money to be used for this particular purpose. In terms of parental powers, as it were, dealing with a college-age student, it's pretty limited.
Yeah.
Because they are an adult, they can make their own decisions, even if they're bad decisions.
What? I've never made a bad decision since I've been an adult. Come on. What are some of the most common mistakes that you see families make when it comes to planning for minor children as part of their estate plan?
It's usually an assumption. And the assumption is, my sister would be great with the kids and she'll take care of them. You better make sure sister is willing to take on that burden. And one of the other things in terms of estate planning is if you're giving sister the power to raise your children, you'd better also give sister the money to do it.
That's a good point.
Yeah. And so you don't say, okay, I'm going to give away all my stuff to Joe, but Sally over here is going to take care of my kids. That's not going to work.
It's not very fair. That's for sure.
Yeah. It's certainly not fair. Yeah. And then the other, again, this is probably a little bit of field, but you may have a child that has some other challenge. It could be a learning challenge, could be a health challenge, whatever. And so in a full estate plan, we would put together a special needs trust that would specify where that money is to go, any assets that are in the estate, how they're to be spent in terms of supporting the children and taking care of their health issues, so forth.
Okay. So you can get pretty granular with this. You can really customize your estate plan to talk about like real specific stuff you want.
You can. What you can't do is what we call in law school the cold, dead hand reaching out of the grave. You can't tell people what to do after you're gone. In terms of we had one recently, we had to litigate this case where the decedent didn't like the man that the beneficiary had been spending time with, and said, I think she's got a substance problem. So as long as she has a substance problem and is hanging out with this guy, don't give her the money. And the trustee took that position. The problem is that the beneficiary, our client, didn't have a substance problem, and we got her tested and proved that to the court. And she hadn't hung out with this guy for years. He moved to Colorado. It's in your neighborhood now. And she was in California. So it was completely irrelevant, but we had to prove it to the court, and the court employed that analysis of you don't get to reach out the grave and control what people do in the future. And so that wasn't enforceable. So there's a line about what you can do. Now, most of that we've talked about thus far having to do with children is fine, because as the parent, you do get to control what they do.
Right.
Do that for someone who's an adult.
In that scenario you just mentioned, what if she was hanging out with that guy, or what if she did have a substance abuse problem, or both? Would they honor the request in the will?
Good question, Kevin. And the answer is, I hate to give it, everybody hates attorney answers. It depends. Right?
It depends. Yep. I was waiting for it.
One of the things that there can be conditions on distribution to someone who has a perceived or actual substance issue. And they can be required to either prove up that they don't, or to participate in substance rehabilitation plans, right? Or with respect to the person they're hanging out with, I think the court would take a look at that and say, well, she's an adult, he's an adult, they can do what they want to do. If they're not doing anything that's illegal, you just don't like their judgment. Oh, well, if the will says give her the money, if she gets the money and puts it in a fireplace and burns it, that's her right. She can do that. Right? It's not something for the court to decide, and not something for a trustee or an executor to decide, because a will and a trust is an instruction book. It's not recommendations. Mm-hmm. It's do this. And we've had a fair amount of litigation when either an executor of a will or a trustee of a trust has decided, well, I don't really think that's good. I'm in charge here. No, you're not. You're the person who gets to follow the instruction book.
You just follow the instructions. Exactly.
Yeah.
Exactly. Yeah. Yeah. I feel like it's one of those things where, you've mentioned it already, that parents don't want to think about this. I have a 4-year-old. I don't want to think about that either, but it's important to have a plan in place. Before someone comes to talk to you, what kind of advice would you give them, like, to get their ducks in a row, to make sure that they have a good starting point before they come and sit down with you?
I think the most important thing is, if they're partnered, whether it's a legal partnership or they're married or they just live together, whatever, talk about it. And, if there's children, both parents should be involved in, what do you think should happen if we both die tomorrow? Right. And they really need to have that. It's not any other kind of preparation. It's being able to understand, be clear about, and express what your desires are. It's the most difficult thing. It's funny, when I do estate plans, the two hardest questions for people is, what do you want to name it? Because you don't have to name it after yourself. And who do you want to be your executor or your trustee? Well, it could be so-and-so. What? Husband wants one as an executor and wife wants somebody else.
Right.
So you've got to resolve that. And in terms of the juxtaposition between choosing someone to execute a will versus an agent for power of attorney for healthcare, there are two different requirements. So in the will, you want somebody who's financially competent, who's reasonable and legitimate. On the healthcare, you want somebody who understands what your desires are.
Right.
And frequently, those are two very different skill sets.
Very much so.
And so you want to really appoint the person or persons who are appropriate. And it reminds me to mention that for an executor of a will, trustee of a trust, I generally do not like or recommend co-trustees. It leads to a lot of problems.
Yeah. Like an infighting kind of thing, like a disagreeing kind of thing. Yeah.
Absolutely. One says yes, the other says no. On the other hand, the one I've already mentioned is a healthcare power of attorney. I do recommend multiple agents in that sense, so that no one person has to carry that burden. There's a lot of things to think about, and that's why we ask a lot of questions when we meet with clients to find out what they really want. If people think of an estate plan as having to do with things and money, They don't think about their kids. They don't think about what happens if they get sick. They don't think about all those other issues that can arise. And that's what our job is, to bring those to the forefront so that they actually do think about them and make an informed choice, understanding what the parameters are and the implications are.
It speaks to the idea that people just don't have a lot of knowledge or information about estate planning. A lot of people do anyway. They just don't understand the process and what all is involved.
Yeah, absolutely. Which is why I do this podcast,
Right.
which is why I've done a bunch of videos, to try and shed light on that so people can make informed choices.
Right. Absolutely. All right. Well, thanks for listening to Inheritance Solutions for a Diverse Community with Richard Hall. For more information, you can find Richard on social media and visit bottomlinelawyers.com. Also, when you go to the website, there's a link for YouTube. On there, you'll find all these podcast episodes, including other inheritance videos, lots of information up there. So if you have questions, it's a great place to start. Richard, always great talking to you. Thanks so much for being here.
Sure, Rick. Thanks so much, Kevin. I appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.